The first thing we should always check is the AIC website, which is full of government grants, as well as information on what to do to care for people with dementia. The second thing is frozen assets. Assets are, for example, your bank accounts, which includes your savings, perhaps investments, anything that are of value that can be sold, which they can raise funds in order to pay for your medical care. And why are they frozen? Because I think if you understand it from a legal perspective, if a person is the main signatory of a bank account and now has dementia, if you go down to the bank will not allow him to actually sign. So in that case, the assets are frozen, and what happens is that the law will have to come in order to empower somebody, perhaps a loved one, a family member, in order to start to manage these assets on behalf of the loved one with dementia. LPA is the acronym for Lasting Power of Attorney, which is a legal document. So once we execute an LPA, we appoint somebody to become what you call your donee, who would then manage your affairs when you lose mental capacity. Your mom now has dementia. Maybe it's early onset dementia. I would actually strongly recommend you to do a lasting power attorney as soon as possible. Well, a lasting power attorney is a form which you can download from the Public Guardian website. After that, what you need to do is to go to something called a certificate issuer. Certificate issuers includes doctors, like GPs who've been accredited with the Office of Public Guardian, lawyers, like myself, and finally psychiatrists, who will then examine the person who wants to create this LPA and to check whether the person has the mental capacity to do it. If your mom has dementia, does she really understand what she's signing? Because if she doesn't understand it, it can be challenged in court. Who is best to assess it? A psychiatrist. And when a psychiatrist assesses your mom is fit and understands what she's signing, you can then safely and also securely manage your mom's affairs. So how about if it was a later stage of dementia? Even if it's not done, don't worry. The law will still come in to have something called a court-appointed deputy. A court-appointed deputy is somebody who says that they want to take on this responsibility of caring for the person without mental capacity. There's an application that has to be filed to court, and the judge will have to scrutinize the application to see whether the powers of management should be granted to this person. A deputyship is a much longer process. It's a much more expensive process. If you find yourself that you are unable to afford a deputyship application with a private lawyer, you can always check out the Legal Aid Bureau, which is the government source of legal information as well as legal support and assistance for Singaporeans and PRs. So let's just see, what do we need when we're writing a will? We need to be able to instruct the lawyer writing it on what to write into the will. So for that to happen, you need to have mental capacity. In this case, it's called testamentary capacity. And if you have testamentary capacity and you're able to tell a person what you want, then your will is valid. The way that the law is that for dementia cases, it is actually very, very nuanced. For example, if in that morning itself, the psychiatrist assess that you are able to understand, you're able to communicate, your will is valid. Even though in the afternoon you might not be able to understand anything, that will is still valid. I would have to say that she should have already appointed you as her lasting power of attorney donee. Means you're empowered to go to the bank, and even if the account is in her sole name, the lasting power attorney will then empower you. Of course, the bank will do their checks as well on that part. As a donee, you take on the position of a trustee. And as a trustee, your number one responsibility is keep good and clear accounts. If your mom didn't do a lasting power of attorney, then the court-appointed deputyship will come in, and then what the court will do is order you to close this bank account that your mom has in her sole name, and then after that open a brand new account where you, acting as a trustee, will be able to make withdrawals from that bank account itself. If you were a court-appointed deputy, there is an obligation imposed upon you to actually do an annual report, an accounting report to the Office of Public Guardian, to just submit to them exactly how you use the money in the course of the year. The most important thing is the money goes to your mom to ensure that she has the best comfortable care that she can afford with her money as long as she's alive. And I think that is the principle that we really want to bring across. I think financial abuse here is really when you are actually misusing a person's assets, right? For your own benefit. There was this huge case of financial abuse of a person who had diminished mental capacity. Madam Chong was a very rich widow. She made friends with this very young man by the name of Yue-En Chong. Madam Chong executed a lasting power of attorney in order to appoint Yue-En Chong as a donee. She did something called lasting power attorney form 1. It means that I trust you. Please basically manage my life as best as you can. I'm not going to enforce any restrictions upon you as well. In this particular case, as a donee, what Yue-En Chong did was to actually transfer monies from Madam Chong's bank account into his own bank account. Thankfully, the court found that Madam Chong could revoke Yue-En Chong as a donee. If you are able to revoke somebody because you still have the mental capacity to do so, and you feel that you just can't trust them anymore, then please do so. It's always more important to do that. At this point in time, I would like to mention lasting power attorney form 2. It's actually crafting your own wishes into the form 2 to state how do you exactly want your donees to take care of you, any restrictions you want them to have. So the lasting power attorney form 2 can only be drafted by lawyers, but when you think about it, it also provides clearer directions to your donees on what they can do and what they can't do. In a deputyship, the court can also order very specific and very limited powers of how you can go in to withdraw monies from the patient's bank account. So this will actually form a limit, and that will also prevent financial abuse. If we feel that there's no one that we can trust, or we feel that we want somebody who's a professional, who is liable and who is answerable to an ethics board, the Singapore government has introduced this regime called professional deputies and professional donees. You can either appoint them under a lasting power attorney to be your professional donee, or in the case that you have already lost mental capacity and there's no one around to care for you, then a professional deputy could step in order to manage your affairs, in order to unfreeze those frozen bank accounts. When we actually do appoint somebody to take care of us, appoint somebody who we can trust, that will have our best interests at heart, and will not actually use our assets, right, for purposes that will disappoint us.